So this is the criminal law checklist for the first year student's bar exam. It is on criminal law. It doesn't cover the constitutional aspect or the criminal procedure aspect. It's just a general criminal law. So without further ado, I'm going to go ahead and read off the list that I made. And this is basically the outer checklist, and then as I get into it further, there will be details. And I may repeat some of the crimes. Okay, so basically for your essays and your multiple choice, at least for the multiple choice, assume common law unless they otherwise tell you. And with the thing that you're going to jot down, you're going to remember the sentence, fairly interesting characters cuddle their mates daily. I made this one up. And what it is FICCTMD. The fairly stands for fundamental 4 elements of a crime. The interesting stands for inchoate crimes. The C stands for crimes against the person, and the C stands for crimes against habitations. Then the T goes into theft crimes, and then the C goes into crimes against the property interest, and then M is miscellaneous crimes, and D is defenses to crimes. And this is further broken up. So I'm going to go ahead and just read this inner checklist, and I'm just going to do a quick adjustment here because I wanted to format this a little bit differently. Hang on a second, guys. So I'm just going to fix this hanging indent. Okay, it's not working. Alright, I'll fix it later. Alright, let me just read this off for you. So this will be in a separate playlist for crimes, and then also a first year students law playlist. And so criminal law outer checklist mnemonic again is fairly interesting characters cuddle their mates daily. FICCTMD. Okay, here we go. Fundamental 4 elements of a crime. Conduct or a voluntary act, actus rei, excuse me. 2, culpable intent, mental state, that's mens rea. And 3, concurrence. Generally, it has to be the state of mind and the act and the harmful results. So there's going to be 3 things in the concurrence generally. So the harmful result must occur at the same time as the criminal intent, or it's got to proceed or coexist with the criminal act in some way activated, okay? So then you have to have causation. The act was in fact the cause of the harm, the but-for cause. The act was the proximate cause or the legal cause of the harm. So the necessary mens rea may not continually be present until the forbidden act is committed, as long as it has activated the conduct that produced the criminal act. However, for criminal liability to occur, there must be either an overt or voluntary action or a failure to act when physically able as required by statute or law. Now, for 2, inchoate crimes. These are the SAC crimes: solicitation, attempt, and conspiracy. Note, Pinkerton's rule: each member of the conspiracy can be held chargeable with all the crimes in furtherance of the natural and probable consequences of the unlawful act even if they didn't commit the act. I'm going to detail this a little bit further and add some more in after I get through the main outer checklist here. Okay, so crimes against the person. Homicide and non-homicide crimes, such as assault and battery, kidnapping, and their defenses, will be discussed below. But remember, there's the felony murder rule and the perpetuation of inherently dangerous felony, BARRMKSS, burglary, arson, rape, robbery, mayhem, kidnapping, sodomy, sexual molestation, at common law, inherently dangerous. Attempted, BARRKS will suffice. Now, we have different laws modernly than there are at common law. So just keep that in mind. Pay attention to the call of the question. Crimes against habitation, burglary, arson, theft crimes. There's 5 general theft crimes: larceny, larceny by trick, embezzlement, false pretenses, robbery, and receiving stolen property. Crimes against property interests: forgery, uttering, extortion. Miscellaneous crimes: misprision, compounding, breach of the peace, malicious mischief. Defenses to crimes: justification defenses, self-defense, defense of others, defense of property, crime prevention, public authority, domestic authority, and necessity. Also, excuse: insanity, diminished capacity, infancy, intoxication. Definitions below. Mistake of fact, mistake of law, duress, consent, entrapment, and mitigation. Okay, here we go with the definitions. They're pretty much similarly so I'll just shoot with them here. Vicarious liability: one who is liable for the actions of another, based on a relationship between the parties. Accomplice: a person who aids in any way in the commission or concealment of a crime. Active participation. Accessory: usually liable as a principal only if the crime is a felony, not generally at the scene. Solicitation: one entices, encourages, or requests another to do an unlawful act. Attempt: slap is the mnemonic. Specific intent: legal no attempt versus factual impossibility attempt. Apparent ability, preparation versus perpetration. An inchoate crime and specific intent crime. It's got 3 elements to convict: intent to commit a crime, substantial act toward completion of the crime, failure to complete the crime, legal or factual impossibility, and apparent ability beyond mere preparation toward the actual perpetration of committing the intended crime. Note, if a crime was attempted, was not specific intent, such as strict liability, negligence, or recklessness, intent will not be enough for attempt of crimes of that general intent kind under the majority rule. Okay, so that was an attempt. Conspiracy. Conspiracy, remember, this is the SAC crimes: solicitation, attempt, conspiracy. So conspiracy is an agreement between 2 or more persons to commit an unlawful act or unlawful act by lawful act by unlawful means. Conspiracy is the only inchoate crime that does not merge with the criminal offense. So if you've got an attempt, it can merge with the offense if it actually takes place, obviously, and then solicitation would merge. So Pinkerton's rule, again, conspirators are held liable for all offenses committed in furtherance of the conspiracy. Now, with Wharton's rule, for crimes that require a minimum of 2 parties to commit the offense, there can be no conspiracy if only two parties are involved. For example, bigamy, gambling, bribery, prostitution, dueling. Okay, I think I'm going to take this and adjust it. Solicitation. Why did I do solicitation twice? I don't know. When one entices, asks, encourages another to commit a crime with the intent to have crime committed. Crime is committed upon asking. Okay, remember now, conspiracy is an agreement between two or more people to commit an unlawful act. They intend to agree, they intend to commit the crime. Modernly, an overt act is required. At common law, no overt act. Defenses, withdrawal and abandonment. At common law, renounce others that they no longer wish to be involved in conspiracy, terminating participation, liable for the conspiracy but not crimes post-withdrawal. Now remember, conspiracy is the only one that doesn't merge. So you can be charged with conspiracy but not the actual crime if you renounced it possibly. Okay, modernly may require renunciation, notification to authorities, discontinue any aid, neutralize assistance, must be timely. Withdrawal or abandonment. Defendant terminates participation prior to the crime and their actions had not contributed to the crime, or the defendant notified the law enforcement in time to prevent the crime. Homicide is the killing of one human being by another human being. The actual cause, but for the defendant's acts, the result would not have occurred, and thus the defendant is the actual cause of the victim's death and the proximate cause. It is foreseeable that the defendant's acts would have created the result. Thus, the defendant is the proximate cause of the victim's death. Murder at common law. Unlawful homicide with malice aforethought. Malice may be demonstrated by any one of the following: intent to kill, intent to cause serious bodily harm, reckless and wanton disregard for the high risk to human life, depraved heart, or 4, intent to commit felony, the felony murder rule, whereby an unintentional death occurs during the commission of an inherently dangerous felony. So remember, at common law, you're going to look for 4 categories of culpability, or 4 elements. And let's see, first degree murder is murder committed with specific intent to kill, deliberation, and premeditation. Malice murders are committed with premeditation and deliberation or special circumstances. Felony murder rule, FMR, BARRK, these are the different things, and then poison, torture, ambush, or lying in wait. So those are the malice murders, okay? And that includes these other crimes. So there's 1, 2, 3, 4, 5. Premeditation, the idea of killing was entertained prior to the act. Turn the thought of killing over into the mind. Deliberation. Defendant acted in a calm and cool manner, dispassionate, and did in fact reflect on the killing. Second degree murder is murder that's not in the first degree. Mitigation. This is a lessening of the charges from a higher degree of murder to a lesser degree of murder due to circumstances. So if you were a criminal defendant's attorney, You would consider any and all the defenses for mitigation. Also, if you were the prosecutor, you would want to know those things to see if you had a good case. Okay, voluntary manslaughter is intended unlawful homicide without malice aforethought. In other words, heat of passion killing must have followed provocation before the defendant had an opportunity to cool off. Involuntary manslaughter, heat of passion killing requires that adequate provocation, that's objective, the defendant was adequately provoked, there was no time to cool off, and the defendant in fact did not cool off, and a causal connection between heat of passion, provocation, and killing. Adequate acts of provocation, mutual combat. The encounter must be a mutual attack and defense, and that's a physical attack. It's not a psychological sparring. Battery, hard blow inflicting considerable pain or injury. Assault, intent to commit a serious bodily injury. Can't be, light touching. It has to be intent for a serious injury. Now, words are not adequate provocation unless they're also coupled with an overt action. Highly informational words in a very small minority of jurisdictions. Another provocation is adultery, the discovery of one's spouse in intimate infidelity. Outrageous acts upon a member of one's family, such as raping someone in your family or deadly assaulting them. Mistakes concerning provocation, a killing would be reduced to manslaughter if the defendant acted under a reasonable mistake, an imperfect mistake. Sudden revival of passions. Provocation, a person would have been provoked, and the defendant must have been provoked, and then they cooled off. A reasonable person would not have been able to cool off, and the defendant must not have cooled off. Involuntary manslaughter is the unintended killing without malice aforethought. It's an accidental homicide. Misdemeanor manslaughter is a killing without malice, and it's committed during an unlawful act not amounting to a felony. Unintentional killing that occurs during an unlawful act. The act not serious enough, not a felony, to trigger the felony murder rule. Malum in se, wrong in itself. Malum prohibitum, prohibited by statute. Assault. Two types. Intent to commit a battery, specific intent crime. Intent to place another in reasonable apprehension of immediate battery, general intent. Requires awareness. Words are not sufficient, but words coupled with act are. Aggravated, deadly weapon, child, police officer. Battery, the unlawful application of force to another. Force may be applied directly or indirectly. General intent crime. Consent may be a defense as well as the other justification defenses. Kidnapping at common law. Forcible abduction, stealing a person away from his own country and sending him to another. Modern law. Aggravated false imprisonment, forcibly moving a person to another place or secret place. Slightest movement will suffice. Unlawful restraint, necessary confinement. Many states require a secret place. Mens rea, specific intent to move or hide the victim. In relation to other crime, liability for kidnapping is established by strict application. Movement of the victim incidental to rape, robbery, will bring no liability to the kidnapping unless the risk has substantially increased. Mayhem, malicious maiming or disfiguring of another. Mens rea, specific intent to maim. Lesser included offenses are assault, battery, attempted mayhem, false imprisonment, the intentional confinement of another without their consent with no reasonable means of escape, rape, intentionally or criminally negligent sexual intercourse with a woman by a man without her consent. This is at common law, by the way. The laws have changed. Slightest penetration will suffice. Lack of physical resistance is a strong evidence of consent. Intimidation does not mean consent. Intercourse with an unconscious female is without consent. Insanity, intercourse with a female of low mental capacity is not consent. Fraud in factum. Mens rea, general intent, attempted rape, specific intent. Statutory rape, intercourse with a female who is under age specified by statute if she consents, strict liability crime. Mistake is no defense with regard to the victim's age. It is a defense in some states that the defendant reasonably believed that the girl was over the statutory limit of the age requirement. Some states give the defendant a defense if he himself is below the statutory age with a certain age difference. Assault. Intentional placing of another in apprehension of an imminent harmful offensive touching without privilege or consent. Battery. Intentional harmful or offensive touching of another without privilege or consent. Kidnapping. Intentional moving of a person from one place to another without privilege or consent. Any distance counts. False imprisonment. Intentional physical or psychological confinement of another without privilege or consent. Rape. Unlawful sexual intercourse committed by a man with a woman not his wife through force without consent. Modernly, marital status and gender are often irrelevant. Arson at common law. The malicious burning of the dwelling house of another. Must be the house that another inhabits, lives in, sleeps in. If an owner burns his own house down under common law, it's not arson. If the burning creates a high risk that another's residents' homes will catch fire, then it is arson, like if it's an adjoining building or something. Burning of the structure. Malice is the mens rea. If the defendant intends to burn, knows it will burn, reckless. Negligent burning is not arson. General intent crime. Modernly, the burning of any structure is arson without regard to ownership. When an owner intends to burn his house for insurance fraud, this is also a form of false pretenses. Overview of burglary. Breaking and entering into the dwelling house of another in the nighttime with the specific intent to commit a felony therein. Modernly, trespassory entry into a structure with the intent to commit any crime. Larceny will do. Burglary at common law. Common law is the trespassory taking, breaking, and entering into the dwelling house of another in the nighttime with intent to commit a felony therein. Breaking is the actual or constructive breaking to create an opening without consent, any amount of force to enlarge or create an opening. Inner breaking. If a door is opened and part of its structure, for example, are built in. Constructive breaking. Obtained by fraud, threatening to use force, or by using an innocent agent like a housekeeper or an accomplice. Trespass. Without consent, or exceeds consent, or lies to get in. Entry. Any part of the body or any part that it's attached to the defendant's body like an instrument of some type. So if they have like a pole that they're sticking in the house. Instrumentality. Insertion of tools to create the opening for the use in the accomplishing crime. Dwelling house. People regularly sleep in it. Unoccupied structures are not dwellings. Newly built homes not yet occupied are not a dwelling. Temporary absence of a dwelling does qualify, like if you're away on vacation or you're at work when it burns. Buildings within the curtilage. Buildings not living quarters, but still within the fenced-in zone are considered to be dwellings. Barns, stables, garages, but not any buildings that are separated by highways. So if you had a big farm and you had a building across the highway, that would not count. A fence is not required. Of another. Of another means other than the defendant. Occupancy controls, not ownership. So it could be that you're renting out a house and someone else is occupying it. Okay, so the dweller cannot commit burglary on his own home if he's still in possession of it. One can commit burglary by entering a home released by another. You know what? I think, okay, sorry, but, I think I kind of, all right, let's just continue. One can commit burglary by entering a home leased to another. Where there are multiple dwellings or joint occupancy, no burglary can be committed. Guests or transient lodgers are not recognized as dwellers for the purpose of burglary. Nighttime, sundown to sunrise, concurrence, breaking and entering intent must occur at the same time. Intent to commit a felony, mens rea. Specific intent must be upon breaking and entering. Larceny in common law is a felony. Modernly, any structure, nighttime element and breaking element are eliminated. Inner door example. I grant you access to my home, you break into my hallway closet. Larceny, the trespassory taking and carrying away of the personal property of another with specific intent to permanently deprived. Guys, I don't know what happened, but I think that I skipped a page or something and the flow is a little bit off, but I do apologize for that. So I'm just going to continue with this until the end, and then I'll fix it afterwards. Probably I'll have to do that later because I'm running out of time. I'll just put this up the way it is, but I'll fix it later. Okay, by innocent agent, have an innocent person commit larceny for you. They would be ignorant as to the deed. Larceny by trick. Larceny which is not trespassory in nature, with the victim's permission, obtained by deceit. Embezzlement. Fraudulent conversion of rightfully entrusted personal property. False pretenses. Obtaining title by means of false representation of fact with the intent to defraud. Robbery. Larceny from the person by means of force or intimidation. Receiving stolen property. Acquiring or controlling property known to have been stolen. Merger rule. Lesser included offenses merge into the greater offense. Remember with inchoate crimes that conspiracy doesn't merge. Okay. Misprison. Concealment of a known felony of another. Forgery. The fraudulent making or altering of a writing with the intent to defraud or deceive. The fraudulent making of a false writing that has apparent legal significance, or the making of a false writing with the intent to defraud. Writings of legal significance, there's 9 of them. Contracts, wills, promissory notes, negotiable instruments, receipts. bonds, diplomas, letters, recommendations. Other activities similar to forgery, not to be confused with it, are reproducing a copy of art, such as a painting. That's not forgery. Paintings don't have legal rights or obligations. False writing, making a document that misrepresents facts or tells a lie, is not forgery. A document must have been made with a writing which is not genuine in itself, i.e., counterfeit. Fraudulent intent. A writing must be altered with the intent to make a wrongful use of the forged document. Misrepresentation. Making a false statement of fact without regard to the truth, intended to induce a party to detrimentally rely on it. Malicious mischief. Malicious destruction or defacement of another's property. Actus re. Physical aspects of the crime. The act, the physical act. Mens re. Defendant's state of mind at the time they committed the act. By the way, I have trouble pronouncing those two Latin words. So, uttering. Offering as genuine an instrument known to be false with the intent to deceive. There's excuse. 3 kinds of insanity. There's the insanity test criteria are MI, MDI. So that's the McNaughton rule, Irresistible Impulse, MPC, otherwise known as substantial capacity, diminished capacity, and infancy. Those are the 5 main general ones. But under the capacity, intoxication comes into that. So, okay, so well, the McNaughton rule is kind of old. It came out in 1843, and it's a right or wrong test. The defendant does not know the nature or quality of their act, and does not know the act was wrong. So it's the legal and moral aspects. It's now called the not guilty by reason of insanity rule. Irresistible impulse is when the defendant lacks the ability to control their conduct, and it's just loss of control. A minority of states sometimes add that in with the McNaughton, but it just depends. Model Penal Code, American Law Institute, substantial capacities. Now, this is 1962. They were codifying the laws, and some of the laws are almost exactly the same. So you might hear of this named a couple different ways. A lot of people just say MPC, but I don't know which came first. But anyway, with a substantial capacity due to mental disease or defect in reasoning, the defendant lacks substantial capacity to conform their conduct with the law or appreciate the wrongfulness of their conduct. Cognitive test. If anybody knows, feel free to let me know. I can edit this and fix it. I'm probably going to edit this and fix it when I get some free time. Durham rule, but for mental illness, the crime would not have been committed, and it's a minority rule. Mental defect is only one of a few, is only in a few states. I think New Hampshire was one of them, and it's rarely used because it's too broad. It's diminished capacity is an impaired mental condition short of insanity, which is caused by intoxication, trauma, or disease, and prevents a person from having the mental state necessary to be held liable for the crime. Infancy due to age. Incapacity to commit a crime between 0 and 6. Just not capable of it. Conclusive presumption of incapacity. And between the ages of 7 and 14, there's a rebuttable presumption, and the court might weigh whether or not to treat the child as an adult. The prosecutor might too. And a juvenile is treated as an adult or over. If they're over 14, modernly, either they'll be prosecuted either way in juvenile court as juvenile delinquents or as an adult. It just depends on the jurisdiction and the prosecutor. So the Insanity Defense Reform Act came about in 1984. I don't think you need to know this for the bar, but it might be a good idea to know it. It basically is post John Hinckley. When Reagan was in office, he wanted to change these laws. Hinckley got off on his crime of shooting to kill the president, and he was put away for a reason of insanity, for major depression and delusions. And what they did is they put him away for like 30 years, and he actually was released to his 90-something mother in Virginia Beach area. When Trump was in office, but basically the law was changed in 84, and I think it was a response to Hinckley. And basically it shifts the burden back to the defendant to prove that their insanity was so bad that they didn't know right from wrong, and that they had this irresistible impulse or whatever, coupled together with the other. It just depends. It really makes it harder to get off of a crime. Kind of go back to the McNaughton right or wrong test. Okay. Intoxication types. Involuntary and affirmative defense to any criminal or negligent charge, not just specific intent. Voluntary is used to negate specific intent crimes. Consent, because consent was given freely, there was no crime. Crime prevention, reasonable use of non-deadly force to prevent a crime. Imperfect self-defense. Oh, excuse me. Yeah, same difference, I guess. Okay, so imperfect defense of self, the use of force by one who makes an honest but unreasonable mistake that force was necessary to counter an attack. Defense of self. Reasonable force necessary to protect oneself up to and including the use of deadly force. Defense of others. Reasonable force necessary to protect others whom the defendant has a special relationship up to and including the use of deadly force, modernly, to protect anyone. Defense of property. Reasonable, non-deadly force necessary to protect one's chattel. Necessity. A person is privileged to enter the land or interfere with chattels of another if it's necessary to protect a person from death or serious bodily harm. Mistake of fact may be used to mitigate the required mens rea necessary to be held liable for a crime. Mistake of law. No defense under common law, possibly a defense under the MPC. Duress. Defendant reasonably believed that unless they committed the crime, that they or some third person would suffer imminent death or serious bodily harm by the perpetrator. Okay, well that's it. Now, I was told by a bar prep person that you should assume common law on the multiple choice for the baby bar unless they give you different instructions. So when you're answering the multiple choice, since you have memorized which is modern law, which is common law, you will know which to lean on when answering multiple choice. When you're answering a essay question, you're going to look at the question and the instructions on that. And if it says, what is it at modern law, then you're going to go with modern law. Alright, well, thanks for watching and best of luck. Take care. Bye.